my name is Elisa. This video is dedicated to my Land Law 1 assignment. Before I begin, let's take a look at the question. The focus of this question is twofold. First, it requires a discussion on the requirement of formalities in land law. Second, the question calls for a critical evaluation on whether such formalities detract the autonomy of the landowner in dealing with his or her property. Let's begin by diving into the first part of this question. What is formality? With reference to the article by P. Critchley, she defines formality as a requirement that matters of substance must be put into particular form in order to have a specified legal effect. Essentially, formality encompasses two important things. First thing is that formality follows a particular form. For instance, the current English land law formalities take the form of writing, registering, or even a requirement that the transaction be completed in front of a witness, just to name a few. The second important criteria of formality is that it is mandatory to follow the prescribed forms in order for a transaction to have a legal effect. Hence, when a landowner deals with his or her property, it is important that he abides by the formalities involved. Having understood what formality is, this leads us to the main question. What is the current position of formality in relation to English land law? From owning a land to leasing it out to selling it to the subsequent buyer, all of this involve formalities. But where should the discussion begin? A good starting point is from the perspective of the landowner himself. The discussion will begin by laying out the formalities that a landowner must follow in order to secure his or her legal estate in an unregistered or a registered land, followed by discussions on the formalities required to grant leases and to do conveyancing in land. Each discussion will be followed by a specific evaluation on whether such formality detracts the autonomy of the landowner. The discussion will then shift to a general evaluation on the requirement of formality as a whole, ending with the conclusion that formality is important, even though it detracts the autonomy of the landowner to a certain extent. The requirement of formalities vary according to the types of land. In the United Kingdom, around 15% of the land is unregistered. In order that the landowner secures his right to the land, he must demonstrate that he has a title deed. But things could be a bit more troublesome when it comes to a prospective buyer who wants to be the new landowner. Prior to purchasing the land, the buyer must investigate the root of title, stretching as far back as 15 years to ensure that the seller has a good and safe title to pass on. In addition, the buyer has to make a thorough physical inspection of the land in order to ascertain whether there are any obvious defects of title or any third-party rights attaching to the land. Such third-party rights could either be legal interest or equitable interest. A very important notion that detracts the autonomy of the buyer or the new landowner is the fact that legal rights bind all the world. This means that if a person buys an unregistered land, the new landowner will be subject to every legal right binding on him or her, and to some extent, this is unfair. For instance, the Land Charges Act 1972 requires certain equitable rights to be registered under the Land Charges Register. This includes equitable easements, equitable mortgages, and equitable leases. If the charge is registered correctly against the name of the estate owner, Section 198 sub 1 of the Law of Property Act 1925 dictates that the registrable land charge is binding on all future purchasers and transferees of the land. This detracts the autonomy of the landowner, as it does not matter whether the purchaser actually knew or did not actually know of the existence of the charge. However, it is arguable that the autonomy of the buyer or the new landowner is not affected if he has done a proper search. For example, in Diligent Finance and Outland, a charge was made against the wrong name, but Diligent Finance managed to search for the correct name. Consequently, the court held that the charge was not binding on Diligent Finance. Alternatively, if the buyer has not done a proper search, the registered charge will be binding on him, as demonstrated in Oak Cooperative Society and Blackburn. These cases highlight the importance of conducting a proper search before buying an unregistered land. On one hand, It is argued that this formality violates the autonomy of the new landowner, as he is forced to be bound by third-party rights unless proper search has been made to reveal some error in the registers. However, Martin Dixon argues that it is not unfair for legal rights to be automatically binding on the new landowners, as such rights are apparent to a purchaser who investigates a purchase properly. For example, it is obvious to a purchaser when there is a tenant occupying the land, so he could act accordingly by lowering the purchase price or cancelling the purchase. Another important formality operating in unregistered land concerns equitable rights which are overreachable under Section 2 and Section 27 of the Law of Property Act 1925. These are the equitable rights not registrable under the Land Charges Register, such as beneficial interest under a trust. Overreaching tax effect in the purchase money paid by the purchaser to the two trustees. When overreaching takes place, the beneficial interest under the trust will be detached from the property, as seen in City of London Building Society and Flag. From the perspective of the seller or the owner, overreaching might detract his autonomy in a way that he might not want the cash equivalent for his interest in the land, but would prefer to remain in physical possession or otherwise use the land. Overreaching prevents this. However, from the point of view of the purchaser or the new owner of the land, overreaching offers him the liberty to be free from being bound by an equitable interest which is overreachable. In this regard, the autonomy of the new landowner should be given more weight, as it would not be fair for him to be bound by an unwanted interest. Whereas in the case of the seller, at least he is compensated by money. That sums up the formalities in relation to unregistered land. So what about registered land? Given the time-consuming process in discovering the bundles of title deeds and doing physical searches, the Land Registration Act 2002 was introduced to replace the old 1925 Act. Section 4 and Section 27 of the Land Registration Act 2002 mandates that an estate to be registered on its transfer or creation in His Majesty Land Registry. Hence, the current position in law is that a person must register the title of his land in the registry system. Under each registered title, there are accorded details about the current owners, the right affecting the land, such as mortgages, and the type of estate. Some landowners may view this formality as detracting their autonomy, since all of their personal information will be registered in the system and searchable by subsequent buyers. Arguably, a system of registration helps to facilitate e-conveyancing with the transfers of estates and interest in land electronically. When a landowner has followed the formality to secure his legal estate, either by showing proof of the title deed or registering in the system, a landowner can do everything he wants with his land. This includes conveyances of land. A landowner may transfer his freehold property by way of sale to another person, but this is subject to certain formalities. First, there must be a written contract signed by both parties in accordance with Section 2 of the Law of Property Miscellaneous Provisions Act 1989. Second, the conveyance has to be formalized by a deed under Section 52 of the Law of Property Act 1925 in order to have a legal effect. Other than conveyances of land, a landowner may also lease out his property by following the formality requirement. It was confirmed in Bruton and London and Quadrant Housing Trust that a lease could exist if there is a right to exclusive possession for a term certain, payable at rent. However, for a lease to take legal effect, Section 52 of the Law of Property Act 1952 requires a lease be made by deed in order to secure the tenant's legal interest. It is important to observe the formality of a deed so as to prevent the landowner from abusing his autonomy as a landlord. This was seen in the case of Sommer and Hazelhurst, where the landowner forced the unmarried couple to sign separate agreements, thereby rendering the lease as a mere license. Although landowners should have the autonomy to grant leases in any terms they prefer, there has to be a mechanism of formality in place to prevent abuse of autonomy by the landowner, as seen in Sommer. In this context, the formality of a deed is very important. As we have discussed the current position of formality in relation to English land law, it is now time to evaluate in general whether the requirement of formality detracts the autonomy of the landowner in dealing with his or her property. The main argument is that formality detracts the autonomy of landowners in terms of their money. This is because formalities incur additional cost. For instance, the transfer of ownership in the land registry system requires a costly initial registration, which ranges from £200 to £300. If a buyer is purchasing a property and requires local authority searches, such as planning or environment searches, it all incurs extra cost and can range from £250 to £450. Nonetheless, it may be argued that the fees paid in such transactions can be used by the state to subsidize other socially important work, such as legal aid cases. In this regard, the autonomy of the landowner is not sacrificed for nothing, but rather it is for the benefit of the community. This, in turn, may help to generate more income and boost the economy of the state. Another argument that the requirement of formality detracts the autonomy of the landowners stems from the fact that landowner himself may be unaware of the formality. Thus, it is unfair to impose such formality on him. Most of this happens in relation to family matters, particularly the informal trust established in the case of Gising and Gising, which requires trusts of land that be evidenced in writing. This requirement remains applicable today in England in the form of Section 53, sub 1, sub B of the Law of Property Act 1925. While the relationship is still going strong, the parties may not even consider formalizing the trust by writing. Hence, P. Critchley argues that this requirement may be unreasonable. However, it may be argued that the enforcement of formality ensures that people are aware of the true legal and requirement. Hence, it provides a certainty in the law, which is more important than justifying the autonomy of the landowner. On the bright side of the requirement of formality in land law, although it detracts the autonomy of the landowner to a certain extent, there could be many advantages which justifies the limitation of the landowner's liberty. One of the benefits of formality is that it helps to clarify the terms of the transaction. For example, if the formality mandates the transfer of an interest in land to be made in writing, the very act of reducing the agreement to writing will help to clear out doubts in its terms. Further, the requirement of registration of land title helps to facilitate e-conveyancing. As evidently noted, every endeavor to introduce a system of land registration shall be at once easy and certain. In the United Kingdom, the system of registration serves the function of supplying quick title information and security to planners, as well as purchasers. Given the benefit that the system of registration offers, it is argued that the autonomy of the landowner in maintaining his personal information shall be made open to the public to simplify and speed up conveyances in land. Based on what has been discussed earlier, it is safe to conclude that the requirement of formality does detract the autonomy of the landowners to a certain degree. From doing physical searches, to registering the land title in the system, to performing conveyances in land, all of this involve formalities. However, it is submitted that the need to maintain certainty in the law and a smooth system of conveyances outweighs the obligation to protect the freedom of landowners in dealing with his or her property. Should the autonomy of the landowners be protected, the third-party interests should also be protected. Hence, the existence of formality is to help strike a balance to protect the rights of both parties, and therefore, formality is important. That is all for my presentation. Thank you.